All right, just waiting to establish the connection. All right. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel this morning are Justice Eric Neyman and Justice Marguerite Grant. We will be the panel for all 6 cases on the hearing list for today. All cases on the list for today, of course, will be conducted by video conference, as we have been doing since last April, thanks to the good work of our clerk, Joe Stanton, and the rest of our technology team. It has allowed us to continue safely despite the challenges of the pandemic. We are taking the second case out of order, speaking of challenges, because the first case on today's hearing list, one of the attorneys had a power outage. We are working to resolve that, and hopefully we will, but if we can't, we will reschedule that hearing, and we will instead begin with case number 2020 P527, the Commonwealth versus KAIANY F. DASILVA. Attorney Cox, you may begin.
Good morning. May it please the court, I am Jennifer Cox, appearing on behalf of Mr. DASILVA on his appeal from a conviction of larceny by false pretense. The defendant raises 2 issues on appeal. The first argument is that the Commonwealth failed to prove beyond a reasonable doubt the essential element that reliance on a false statement induced Mr. Absar to part with the check, resulting in a conviction based on insufficient evidence. For larceny by false pretenses, it has been said that the gravamen of the crime is that the victim's reliance on the swindler's misrepresentation causes the victim to part with the property. The undisputed evidence here showed that Absar did not give his check because of reliance on the false statement, but rather that it was taken without his knowledge and permission. The evidence showed that there was no causal relationship between the false statement and the transfer of the property. Mr. Absar testified that he tried to give Mr. DASILVA the check, but Mr. DASILVA replied that he did not have the contract, so there was no need for him to take the check. Mr. Absar placed the check on the table. They continued talking. Mr. Absar eventually leaves the room to get a glass of water, and that's when they think that the check was taken. Mr. Absar specifically testified that the defendant took the check.
Is it possible that the defendant's statement, "Could I have a glass of water," could be the statement on which Mr. Absar relied?
I think no, Your Honor, due to the language that it has to be reliance on it. Oh, I see your point, that the reliance on it causes you to part with it. But I don't think his reliance on the truth of him needing a glass of water is what the larceny by false pretenses statute is designed to criminalize.
What about the defendant's text messages over the weekend when the victim text messaged him and said, "Are you going to email me the contract?" Mm-hmm. And the defendant said, "Yes, I will."
At that point, the check is already gone, so that can't.
Has it been cashed yet?
That we don't know. We only know that
has the victim stopped payment on it yet?
So the encounter between Absar and DASILVA happened on Friday night, and then by Monday morning, Mr. Absar realizes the check is gone, contacts Bank of America, and it's already cashed. So, you know, this, I'm drawing an assumption, but I think since Saturday is a banking day, I'm assuming the check was cashed on Saturday, and that's why he was unable to stop payment on it on Monday. But again, I'm drawing an inference. I can't represent that that's exactly the record, only by Monday that the check had been cleared.
I want to be sure, Attorney Cox, that I understand correctly. I mean, and I may have this wrong, but if I understand correctly, it's an intriguing theory of defense here that the evidence was insufficient to establish larceny by false pretenses because it was a straight out larceny.
Yes.
Double jeopardy would not bar trial and conviction on the straight out larceny that you are now conceding, correct?
I suspect you are correct. I would not want to hem future counsel in on that answer, but I think you've identified exactly what the problem is.
I'm a little intrigued, I guess, by the end game here.
Yes, as I said, I think that my hope is, you know, that we are successful on this issue and that becomes someone else's problem. But
well, it's going to be your client's,
right?
Your client's problem, because there's a fairly strong judicial estoppel that would bind him in any, or her, in any,
Sorry. Or him, sorry.
in any subsequent trial and conviction. And of course, it was simply the charging, not even the charging decision, but the presentation of this case at trial that confined the Commonwealth to proof on one of the three available larceny theories, correct?
Well, to answer that specific question, actually, you raised a good point that I would like to speak on, that it was not just the presentation of the evidence. It was also, that was how the complaint was written. The complaint was, and it's, obviously it's in the record appendix, but also the language is reproduced in the brief, that he was charged specifically with larceny by false pretenses and with reference not just to section 30, but to section 34. So I think that would be the argument, should the Commonwealth seek to retry him, of double jeopardy. But I do think the problem is that they could have charged him broadly just with section 30, and we wouldn't be here today. But because that he was charged specifically with larceny by false pretenses, that's what the court, they were only instructed on larceny by false pretenses.
I get it. Let me back up then to the main event here, because we do have this case in front of us, and I won't spend much more time talking about possible future cases. You saw the Commonwealth's response on the question of reliance to the check was made, was written out and signed.
Right.
And why was not the act of making out and signing the check reliance on the false statement?
Yes, Your Honor. I would argue that cannot be the act cannot be the execution of the check, because there's no larceny. So, for example, to follow that to the logical conclusion, if the facts occurred as they did here, where the promise, I'm going to start work on Monday, makes him, induces him to execute the check, meaning to write the check, pretend Mr. DaSilva leaves and does not take the check, so there's no larceny. But on Monday, he fails to come to start the check. The crime of causing him to execute the check still happened, but that's not a larceny. You're
slicing the larceny salami awfully thinly, because it was a two-step larceny. First, you had the inducement, and then the actual physical taking away that all happened in a continuous sequence in the same encounter.
I think due to Mr. Absar's very specific testimony, he's asked, did you give him the check? And he says, no, I did not. I didn't even know it was missing until Monday. So
I understand that, but by inducing him to write the check and then taking it, I don't see how you can, for purposes of sufficiency, separate the act of procuring the property by reliance on a false representation.
Well, then I guess I would go back one step further and say that there's insufficient proof that he induced him to write the check, because he said, I'll need it before I start on Monday. But due to his saying, I don't need it today because I didn't bring the contract, there's no evidence. Absar didn't say, by the time I show up on Friday night, I want to see the check in your hand, to be blunt about it. But there's no, I don't believe on the record evidence that we have that he induced him to write the check.
He didn't coerce him to do it. He didn't demand that he do it, but he certainly made a representation that led to the victim's good faith reliance on that promise to start work on Monday.
Well, to that, I would say it's unclear from my read of the record, and I wasn't looking at it with that precise angle, but I would ask the court to reread Mr. Absar's testimony to the timing, because he does testify that they had a previous discussion about the amount of the overall job, but I'm not sure that DaSilva says, I'm going to need $6,500, before I start the work. I'm not sure that conversation happens until the Friday meeting.
But you're missing the point of my question. It's not that he says that he requires it, but his promise to start on Monday was what served as the inducement to the victim to write out the check.
Okay, but again, there's no causal relation then between the larceny, between the inducement to write the check and the larceny.
If he hadn't written out the check, there would have been nothing for him to steal.
Yes, and I think that's larceny. I think that's larceny by theft. I don't think that's larceny by false pretense.
It was making out the check that made it possible to commit that larceny, and there was a false pretense making a false representation that induces someone to open the door followed by someone entering through the open door and stealing something, why wouldn't that be larceny by false pretenses as well as common larceny?
I certainly understand your point, and I think that that's not what larceny by false pretense is. By the case law, that's very specific, that there has to be this causal relationship that, again, like the swindler's misrepresentation causes the victim to part with the property. Because here, you know, I would just again say that I'm not sure that the inducement happened here when we're looking at it with that angle, that the inducement to write the check.
Signing the check is an operative event in under Article 2 of the UCC to part with the property. It is a necessary and essential element of the of making the property available to the suitor.
I think that I would just cite to the cases cited in the defendant's brief that talk about that, you know, it has to be a voluntary, that it's a voluntary payment or relinquishment of payment. And here the relinquishment of the payment of the money was not voluntary. So I would just cite to those cases, and I would argue that I understand your analysis, but I think that would be expanding what the present state of the law on larceny by false pretenses is.
You have a second issue.
Yep.
You know, I don't mean to belabor this point.
Nope, that's fine. So as to the second issue, the defendant also argues that the court abused its discretion in allowing Officer Lloyd to testify to the substance of a telephone conversation with a caller who self-identified as Mr. DaSilva without the required authentication as the call having been made by Mr. DaSilva. So as the proponent of the evidence, the Commonwealth was required to authenticate the call through confirming circumstances, sufficient for a reasonable jury to find by preponderance of the evidence that the caller was the defendant. So here, the mere fact that the speaker self-identified as DaSilva, according to case law, is not enough. Officer Lloyd does not know the defendant, has no familiarity with his voice. The call was in.
Let me stop you right there. Seems that the lead case you cite is Commonwealth versus Howard, and that sort of begs two questions. The first is, in Howard at page 325, what we said was essentially what you just said. There really weren't confirming circumstances, or as we phrased it, the caller did not reveal any special knowledge about the events under investigation that the defendant alone would have possessed. It seems to me here, by contrast, the officer asked about the reported theft, and DaSilva, who not only gave the name KAIANY, but admitted that he had taken the check, admitted he had cashed it, and this is the transcript at page 117, went on to explain that the victim had worked with him previously, the victim had not paid him, and that he'd taken this as payment for that prior work. Isn't that a material distinction from the Howard case?
I think it is in line with the Howard case, because when we parse out those exact statements that you mentioned, you know, I would ask you to read Officer Lloyd's testimony very carefully. Based on his testimony, it sounds like he is basically saying leading questions, and the caller is answering in the affirmative. As to the incriminating things, you know, which certainly this call was rife with, I would say that those contrasted rather than confirmed the evidence. Because so, for example, the testimony, or excuse me, the statement in the call about, you know, this was payment for work previously done but unpaid. Absar was asked specifically about the previous work, and he said, no, you know, I made all the payments. That's why I was hiring him again. That's why I was calling my brother. We had a, you know, I was referring my brother to him. We had a good relationship.
Well, the payment is not the salient point there. Isn't would a stranger to the transaction be aware that he had even done previous work?
Again, I would ask you to read the testimony carefully to see whether that was the caller offering that statement, or whether that was a question from Officer Lloyd, because I do think that's a difference.
It was the caller who I will reread it, of course, but it was the caller who introduced the previous work as an explanation for his entitlement to receive the money. The officer did not bring that into the conversation.
Oh, yes, I that's my read of it as well. But again, I would say
and so the existence of the previous work, setting apart the false statement of non-payment, was something that was in the knowledge of the defendant, and not of some stranger, and contextual, circumstantial evidence in line with the stuff that Howard was looking for.
Well, I would disagree with that. It's a knowledge exclusive to the defendant, because if it is work that was done in 2013, there's plenty of people that knew about that, including, as I said, that Mr. Absar referred him to his brother, for other work. So, I don't know that that was exclusive knowledge.
Right. But
the
the
defendant,
question
this
isn't,
prior work
it doesn't have to be, we don't have to exclude all of the possibilities. The question is whether it is reasonable to infer from the circumstances that the caller was who they purported to be. And it's possible that the victim's brother called him up to talk with the officer from the defendant's phone. But anyway, that's your argument. We can work with that.
Sure, but I also would point to that was what you just stated was one of the arguments in the Howard case, and where the Commonwealth argued, well, no one but the defendant here had a reason to call the police and say these things, and the court there said, we're not going to go down that rabbit hole. Like, there's plenty of reasons people perpetrate frauds. Like, certainly as a defense attorney, I could speak to that. Like, they don't always make sense, but I don't think we have to go so far as to assume like, oh, it could only be his brother. The point is the court, that the jury is going to engage in this speculation as well. So that's why the judge is required to make this threshold finding. Judge Grant?
The previous work was in Chelsea 5 years before. So is there a reason why a Northbridge police officer would be investigating or asking questions about something that happened in Chelsea 5 years before?
I think, to Justice Green's point, I do think the record shows that the caller was the one who volunteered information about the prior work. I'm not sure if that answered your question.
Yeah, thank you.
Okay.
All right, thank you very much. We'll hear from the Commonwealth.
Thank you very much.
May I begin, Your Honors?
Please.
Good morning. May it please the court, Abigail Salois on behalf of the Commonwealth. This court should affirm the defendant's conviction where there was sufficient evidence before the jury to support a conviction of larceny by false pretense. And Judge Locanto correctly admitted the evidence of the phone call. If I may, I'll start with the first argument about sufficiency. The defendant argues that the Commonwealth failed to produce sufficient evidence that showed a causal relationship between the defendant's false statement and the procurement of the victim's property. However, as was touched on earlier, the defendant's false promise to do the renovation for $12,000 with a $6,500 deposit is what induced Mr. Absar to execute a $6,500 check written out to the defendant. The defendant would not have written the check if not for the defendant's false statement.
You heard the defendant's response, your sister's response to my question about that theory. Her suggestion is that we would be somehow expanding the law of larceny by false pretenses by finding that as the inducement where it was not itself the taking away.
I don't agree with that, Your Honor. If he had not made the false promise that made him write out the check, there would be nothing to take. And as Your Honor touched on earlier with your hypothetical with the open door, it could be both. I mean, it's looking at Section 30. These are all types of theft crimes.
The statute of limitations.
Pardon me?
What's the statute of limitations on the crime? Excuse me. Stepping away for a moment from this case and going back to my opening question about the retrial on a straight larceny question.
I don't want to say the wrong thing, and I'd be happy to look it up.
All right, I can look it up.
I
can look it up. I had not looked at the original complaint to see whether the complaint would be adequate to retry on this. But anyway, we'll go. That's a different question.
Sorry about that, Your Honor. I know the complaint did charge it with Section 30 as well as Section 34, and it's not a terribly old case. I mean, this was, the offense was in December of 2018. The trial took place a year later.
Yeah, I just don't know I don't know the statute, but even that's older than we think. We're starting to reach cases much more quickly than we did years ago. Anyway, please continue.
Yes, Your Honor. So the standard of review, of course, is whether the evidence in the light most favorable to the Commonwealth was sufficient to satisfy a rational trier of fact of the elements of of the offense, and proof may be accomplished by circumstantial evidence and reasonable inferences therefrom. So as we know, the elements of this statute are that the defendant made a false statement. So that would be that he promised to do this job for a specified amount of money, that the defendant intended the victim would rely on it, that the victim did rely on it, which here, as I earlier mentioned, he executed the check for $6,500 written out to the defendant, and that the defendant parted with his property based on such, the victim parted with his property based on such reliance. In these cases, the defendant's state of mind may rest entirely on circumstantial evidence, and I'm looking towards the O'Connell case and the True case. And in this case, the Commonwealth presented the following circumstantial evidence. The defendant took the check and cashed it right away, as my sister previously mentioned. The defendant never sent the contract despite multiple reminders. The defendant was scheduled to start work the next business day, but he didn't show up. He didn't provide any exculpatory excuse for why he didn't show up, that following Monday. The defendant ignored the victim's phone calls and text messages despite the party's long history of phone communication. We know he had the correct phone number for the defendant. And the caller, identified to be the defendant, told the police officer that he took the victim's check to settle an outstanding balance.
Counsel, I have some questions for you about the complaint.
Yes,
I
Your Honor.
understand there's a copy of the complaint at page 7 of the record appendix. And that appears to be the defendant's copy that's unsigned. And I'm wondering, and I understand you said earlier that the caption on that includes section 30, but it says larceny over 1,200 by false pretense, chapter 266, section 34 and 30, parentheses 1. And then below that, in the body of the complaint, it refers to intent to defraud and by a false pretense. Are you arguing that this was sufficient to charge larceny by stealing or embezzlement in addition to false pretenses?
I don't think there was sufficient evidence to charge it as embezzlement. I do think there would be sufficient evidence to charge it as a larceny, certainly. And looking at the King case, for example, explains the merger of the 3 types of larceny offenses under section 30. So here, unfortunately, the Commonwealth is stuck with the complaint as the way that it was written.
Do we know for sure that this is how it was written? In other words, have you checked the docket or the clerk's papers to see whether or not there's a chance that this was amended? And that do we have the official copy of the complaint before us?
So if you look at, I think we do, Your Honor. So if you look at page 3 of the record appendix, that is the clerk's docket. And it says it has sections 34 and 30 listed.
That's under the original charge, and then it has a notation that says amended charge.
Yeah, but so that's what I'm seeing. Your Honor, to answer your question, I think there is certainly sufficient evidence here to charge it as a larceny by false pretense or a larceny. Unfortunately, the prosecutor, it was boxed in as charging it as a larceny by false pretense, but there was sufficient evidence as the facts I just listed, circumstantial evidence to show, aside from just the defendant's failure to perform, that met the elements of the offense of a false pretense.
I understand that we're talking about this as false pretenses, and I just want to be clear about one thing. You're not suggesting, are you, that under the complaint, we would have, and the way that the case was tried, we would have the ability to change this conviction to a straight larceny conviction as an alternate theory, are you?
No, Your Honor.
So it doesn't really matter what the complaint said, except as it may in some subsequent effort to retry the defendant on the same complaint. And if you're within the statute, you'd be able to swear out a different complaint, even if that was an issue. So I don't think we need to get too bollocksed up on the form of the complaint at this stage. Your appeal is the defense of this conviction is going to rise or fall on the sufficiency of the evidence at this trial on the false pretenses charge, right?
Yes, Your Honor. We certainly couldn't change it to a larceny conviction because of the way the jury was instructed, for example,
Right.
and the way the case was tried. But that doesn't mean the evidence wasn't sufficient to support either conviction. If I may, Your Honors, I'd like to move on to the second argument, if that's okay.
Sure.
So in this case, Judge Locanto correctly admitted Officer Lloyd's testimony about the phone call, where it was properly authenticated. As we know, evidentiary rulings are reviewed for an abuse of discretion, and Judge Locanto did not abuse his discretion in this case. A judge must determine whether there's enough evidence, if believed, to convince a jury by preponderance of the evidence that the item, for example, the phone call in question, is what the proponent claims it to be.
So why is this case distinguishable from Howard? And in answering that, could you address Attorney Cox's view that you have to look at the context of the questioning here to see why it's not distinguishable?
I certainly think it is distinguishable from Howard. In Howard, the phone call did not reveal any specific knowledge regarding the crime, and here it did. So the confirming circumstances is, the language of the cases that talk about this is confirming circumstances. I would point the court's attention to Anderson on that case. But here, the confirming circumstances were as follows. The defendant was quite familiar, the victim was quite familiar with the defendant's phone number and provided it to Police Officer Lloyd. Lloyd then asked the Methuen Police Department to contact the defendant. And shortly thereafter, Lloyd received a phone call from a caller identified to be the defendant. And the caller and Lloyd discussed case-specific details. For example, they talk about working with the victim in 2013 and talked about the conversations about the basement renovation. The caller admitted to taking the check to fulfill the victim's purported outstanding payment, which was the jury could have inferred from that he had been caught and he was trying to come up with some excuse why he stole the check. So that's why that case is different than Howard.
You don't need this phone call to support your claim on sufficiency, but you do need it to preserve the conviction, because you can't argue that the evidence was not prejudicial, correct?
That's not what I'm arguing. The bar for
You're
admitting
arguing that it was properly admitted, and we have that argument. I'm just I want to be clear that if we disagree with you, just putting out there, if we were to disagree with you that the evidence was properly admitted and find error in the admission of the phone call, that would not detract from your core argument on sufficiency, but it would mean that we would vacate the conviction, because unless you're arguing that phone call was not prejudicial, but I don't know how you could argue that.
Yes, Your Honor, I certainly understand your point. I mean, certainly a phone call where a caller identifies himself to be the defendant and accepts responsibility for the crime would be harmful to the defendant. But the Commonwealth argues that this was properly admitted. And again, it's up to the jury to afford any weight to that call. There was a brief sidebar conversation where the trial prosecutor rephrased his questioning to say caller identified to be the defendant. And it was up to the jury to decide if that was the defendant and whether to credit that phone call and place particular emphasis on it or not. But again, looking at that ruling, Judge Locanto's ruling is reviewed for abuse of discretion.
In the Howard case, I'm sorry to interrupt, but in the Howard case, where there was an admission made by the defendant, didn't we hold in the Howard case that although there was error in admitting that testimony without proper authentication, it was not prejudicial? Yes.
And I would point to, again, I think that the strongest case for the Commonwealth is the Anderson case, which is an SJC case from 1989, where the court held that a phone call between a witness and a person the witness had never met could still be admitted where confirming circumstances tended to authenticate the identity of the other person, even if the witness didn't recognize the voice. And that's what we have here. There was plenty of confirming circumstances, as I listed a moment ago, and that's why Judge Lecanto did not abuse his discretion. And you know, the standard here is preponderance of the evidence. It's more likely than not, and that's a low bar. So to say that he, you know, to reverse that decision and say that that was an abuse of discretion where there was all of these confirming circumstances, I would urge the court, you know, to not do that where there was all these confirming circumstances, unlike the Howard case.
Did the trial prosecutor file a motion in limine or alert the judge to the issue about the authentication of the phone call before trial?
I don't believe so. I know there was a lot of conversation beforehand where defense counsel brought it up, but I don't believe there was a motion in limine. I can certainly check that and get back to you if I'm incorrect, but that's what I believe.
We can look at the record and determine what we have.
Okay. If there's no other questions, the Commonwealth urges this court to find that there is sufficient evidence before the jury to support a conviction of larceny by false pretense, and the judge correctly admitted the evidence of the phone call between the officer and the caller identified to be the defendant. The Commonwealth respectfully asks this court to affirm the defendant's conviction, and thanks, Your Honors, for your time.
Thank you both. The case is submitted. That concludes the.
All right, we are live and recording.
All right, the next case on our list is case number 2019 P53, the Commonwealth versus David Waterson. You may begin.
Thank you, Your Honor. May it please the court, I am Joseph Schneiderman. I represent Daniel Waterson. Your Honors, the jurisprudence of the Commonwealth has consistently recognized that not all unfair business practices, such as overcharging or poor workmanship, rise to the crime of larceny. There is a substantial risk here that the trial judge convicted Mr. Waterson for overcharging or poor workmanship alone without regard to specific larcenous intent, and in light of that risk, he deserves an acquittal or a new trial. Regarding the Thomases, the Commonwealth emphasizes that Mr. Waterson stole from them by drastically overcharging for replacing parts in a furnace. The record reflects that Mr. Waterson in fact performed work to repair the furnace, and the Thomases initially consented to the $250 service charge on Sunday, January 25th. Before moving more into that, I think a chronology may be helpful here. Your Honors, on Sunday the 25th, Mr. Waterson goes out after hours to repair the furnace in response to Mr. Thomas's call for service. He assesses the furnace, makes a determination that he needs parts, tells Mr. Thomas he will be back on Monday with the parts, charges $250, which Mr. Thomas assents to. He comes back the next day on Monday the 26th with parts, and on Monday the 26th, he says it will be $1,500 in addition to the $250 he previously charged. The Thomases vocally object. Mr. Waterson then takes off. To be certain, this just all raises a fair question of whether the Thomases consented, and there was evidence in the record that Dominic DeSillis called these charges excessive. However, Dominic DeSillis also acknowledged that there is no express prohibition on a flat fee. To translate intent to steal in light of the sheer fact of a disparity is not enough. The record,
What was the charge for $1,500 over an emphatic and direct protest for the appropriateness of that fee, a non-consensual taking?
Your Honor, I agree with Your Honor that the record reflects that there was double direct protests, both from Mr. and Mrs. Thomas. However, the record further reflects at Record Appendix 4, page 20, that the credit card servicer denied their claim. And indeed, the credit card servicer said this was over the quality of the work, not whether the work was performed. That actually leads to my second point.
No, but why doesn't that, even if we accept the presence of that evidence in the record, why does that not go to weight rather than sufficiency?
Your Honor, 6 years ago, the SJC recognized in St. Hilaire that lack of consent is a sine qua non of larceny by stealing. So the question, if consent has been raised, the Commonwealth must prove the lack of consent beyond a reasonable doubt, which takes me back to my point earlier, which is Mr. Waterson either would deserve a new trial or an acquittal. He would deserve a new trial because it is not clear how the how the trial judge resolved this issue against him in the face of him briefing that issue.
Was there a request by your client to make findings of fact?
There was not an express classical request under Rule 26 for findings or rulings. However, this court in Kingston recognized that substance is always what we look to. Mr. Waterson briefed the issue and separated in his post-trial briefing in Record Appendix 2 what the facts were and what the law was, and said, in light of the law, this is why I deserve an acquittal. This court has always considered form over substance. In that light, it was enough to put the trial judge on notice of this theory.
Yes,
Mr. Waterson may not have had the
judge's conviction against that argument indicates a rejection of the theory by the trial judge.
Your Honor, the judge may have rejected it, but again, I hearken back to Kingston and indeed to Kingston's ancestry, which is if the judge has been placed on notice of a particular theory and the judge is silent, there is a risk that the judge applied the wrong theory here. And I'm sorry,
the judge wasn't silent. The judge entered a conviction and did so despite the argument that you're now making. And it seems to me that the detailed finding in the absence of a request for the detailed finding is unnecessary, just going, as you suggest, to the substance.
Your Honor, I apologize if I was not clear here. To go back to Justice Neyman's questions, Mr. Waterson did separate out what he thought the facts were and what he thought the law was. And before Kingston, the SJC recognized a request for a ruling as to why, as a matter of law, one deserves an acquittal is enough to put a judge on notice. And in that light, in light of silence, in light of that, I appreciate Your Honor's point that the judge did enter a verdict slip here. That may be an overstatement to call it silence. I apologize if that was not clear. In that light, the judge was placed on notice of this theory. The judge nevertheless entered a conviction. There is a risk that Mr. Waterson has been convicted of conduct which is not larcenous. And I think in light of that risk, Mr. Waterson deserves the benefit of any doubt here.
Was the consent provided to charge $1,500, or was the consent provided to charge $150, as I think the Thomases claimed?
Your Honor, that's correct. Mr. Thomas at transcript 1 said he believed he was signing for $150. Mr. Waterson thereafter wrote in another zero and said, no, this is $1,500. But I think given that the question...
Didn't at that point, sorry to interrupt you, but at that point, didn't Mr. Thomas and then I think Mrs. Thomas come running out and say, no, we don't agree to that charge? That doesn't strike me as consent.
I agree, Your Honor, that the Gestalt, yes, that's absolutely what happened. The Gestalt certainly tilts away from that. The Thomas's own servicer, though, denied their claim. I think in light of that...
Once again, I think that goes, under the Lattimore standard, the judge is entitled to adopt the view of the evidence, and on sufficiency, the question of whether there was consent or not, it certainly was supported. The servicer may disagree, but the judge is not bound by the servicer's view of the evidence. The judge is entitled to reach an independent assessment of the evidence.
Your Honor, I agree. That is why actually I briefed this as an either or. Either the evidence is insufficient as to the Thomas to show an intent to steal, or alternatively, there is a risk that the judge applied an improper definition of larceny. So if Your Honors think that the evidence was sufficient, given how the evidence raised this question, given how lack of consent is a sine qua non of larceny, but the judge did not articulate why he did it. There is a risk that Mr. Waterson has been convicted and he conduct which is not larcenous, and he deserves a new trial. Indeed, that issue has been compelling in these types of commercial disputes, going back 60 years to when the SJC and the Lewis construction case recognized that.
Why don't we talk a little bit about the firing assembly for the de Oliverists?
I'd be happy to. Your Honors, as to the de Oliveras, the disparity between the $500 total charge and the replacement of a $3.25 nozzle does not by itself translate into knowing falsity because the $500 covers more. First, Mr. Waterson.
What is a firing assembly?
Your Honor, it actually was not. The Commonwealth actually did not introduce any evidence in the record as to what a firing assembly was or was not. Dwight Wheeler called
the term firing assembly, if I recall the evidence correctly, came from your client, the defendant, in response to a question by the customer, the de Oliverists, of what he did. And if I recall correctly, there also was evidence that there is no such thing.
Your Honor, that's correct. The first part is correct, which is that he said he replaced a firing assembly. The second part, though, I apologize, Your Honor, I think is incomplete from the evidence. Dwight Wheeler said there is a firing tube and there is a drawer assembly. And indeed, unlike the Thomases, where Dominic DeSillis testified.
Okay, but wait, let's pause for a moment. Let's accept hypothetically the possibility that by the existence of these other two components, that your client, by saying he replaced the fire assembly, meant to say, and just was using a shorthand for the fact that he was had replaced the firing tube and the drawer assembly. He did neither. So that would be false as well, correct?
I think I might have missed something, Your Honor. I apologize.
He said that he replaced the firing assembly.
Yes.
The evidence tends to suggest that there is no such thing as a firing assembly, to the extent that that there may be some ambiguity over what he meant by saying the firing assembly, by combining the firing tube and the drawer assembly. He did not replace either of those, much less both of them. And so I'm having a difficult time understanding where we get to the point where what he said was true rather than false.
Your Honor, I appreciate the point. I thank Your Honor for clarifying that. I think the problem with the term firing assembly is there was no evidence one way or the other. I appreciate Your Honor's point that he may have used that as a shorthand. There was evidence that he replaced the nozzle. There was also evidence from Dwight Wheeler saying that there were also original parts in the furnace when he opened it up. But the Commonwealth did not clarify what is or is not a firing assembly. Dwight Wheeler called it a drawer assembly. And to Your Honor's question, Mr. Waterson has to know that the statements are false. I appreciate that we may not have
nothing that he replaced based on, I'm sorry, you used the other name, the second technician, but the second technician came in, based on his testimony, nothing that Mr. Waterson replaced could fairly be described as a firing assembly. He made the statement that he replaced a firing assembly. That statement, a rational fact finder could find on that evidence, was false.
Perhaps, Your Honor, a rational fact finder could find that that was false. However, I go back to where I started, which is there is a risk that the trial judge convicted Mr. Waterson of conduct which is not larcenous. Although I appreciate Your Honor's point that Dwight Wheeler, who was the second technician, as Your Honor aptly pointed out, said, I don't know of a firing assembly. What I am seeing here does not indicate an out-and-out replacement. All I am seeing is a replaced nozzle. Dwight Wheeler ultimately had to fix the furnace 3 different times. The Commonwealth didn't introduce any evidence of standardized terminology. And Mr. Waterson, again, going back to Justice Neyman's question, briefed this issue of how and why he deserved an acquittal as a matter of law, and indeed questioned whether or not the violations of the regulations could function as surrogates. And indeed, hearkening a bit to the second argument, I think accepting the violations or accepting a should have known standard would upend the law of larceny, because false statements, a defendant must know they are false when he makes them, and indeed knowledge is personal to a defendant. So I think in light of the judge's, Justice Grant?
I have a question about your Yassine argument in your brief.
Mhm.
How is it that your client was prejudiced by the judge's deferral of the required finding motion that was made at the close of the Commonwealth's case?
Your Honor, my client has the absolute right to hold the Commonwealth to their burden of proof. And I think a motion, when it is made, should operate to stop the presses. I appreciate the Commonwealth's point that Judge Tucker and the parties all said we need more here to assess this, but there were steps that could have been taken to do that. And indeed, Mr. Waterson, by testifying, opened himself to potentially
Schneiderman, you have not gone to the question of prejudice. What was the prejudice?
The prejudice was that Mr. Waterson testified and was open to devastating cross-examination, just like in Yazin.
Do you agree that this was invited error?
Your Honor, I see the Commonwealth's point that this may be invited error, but
your predecessor asked the judge to defer ruling the decision. So do you agree this is invited error?
I think if the court sees it that way, that it is invited error.
I'm asking you the question, respectfully.
I see. I'm sorry, Your Honor. I don't mean to evade your question. I think if it is invited error, but I think in any event, findings resting on insufficient evidence or substantial risk, and Yazin is clear, and it's from time immemorial, defendants have had the right to hold the Commonwealth to their burden of proof.
I think
I have two more questions.
Okay.
I know you're out of time, but if I may, Chief Justice Green.
Please.
So my follow-up to that is, I just want to be clear, you're not arguing structural error here under Yazin, are you?
No, Your Honor. I'm arguing that he had a vested right under Yazin.
And then my last question is with respect to the photograph. I'm aware of only one case. It's Commonwealth versus Darby. I don't think either party cited it. Darby's 37 Mass Appeals Court 650. That's the only case I'm aware of where this court of the SJC has, in a jury waived case, reversed a conviction based on the submission of a photograph. Are you aware of any other such cases?
Your Honor, I was not aware of Darby. I'm happy to look at Darby and follow up with the court with a letter if the court desires.
I don't think a letter will be necessary, but I think when you read Darby, you'll understand the point. The level of inflammatory risk in the photograph is of a different character than what we have here.
I appreciate the point. I will look at Darby. I thank the court for your time.
No, thank you.
For the Commonwealth, Attorney Reardon.
Good morning, Your Honor. Suzanne Reardon, Assistant Attorney General on behalf of the Commonwealth. In terms of the, if we start where my brother started with the Thomases, I think it's clear here that both of the Thomases did not consent to this charge. It's not entirely clear on the record, but it does appear that the defendant first wrote in $150 and then added a zero. If you look at the record of volume 4, pages 10 and 25, the receipt does look like a zero was added in. So the fact that the Thomases testified that they did not consent and that they thought it was a $150 charge is borne out by the record in terms of those two documents.
What is your response to the defendant's argument about the absence of a direct finding and the risk of conviction on an improper ground?
Your Honor, as was discussed, the defendant didn't ask for written findings. The judge wasn't required to give them, and I think we can assume that the judge knew that the judge considered these defenses as he was required to do, and came to the result that he did, and finding the defendant guilty on 2 of the 5 counts. I think there was enough evidence to support his inference that the defendant unlawfully took away their property, where Mr. Thomas clearly testified on transcript 1, pages 188 and 189, "I don't agree to that price, don't charge it to my credit card," is the words he used to the defendant. And when we think about, he described the work done as between half an hour and 45 minutes to charge $1,500 for labor. There's a reasonable inference that that is just incredibly out of the scope of a reasonable price.
What do you have to say about the de Oliveira's?
So the de Oliveira's, as was discussed also earlier, it was the evidence made clear that the part that the defendant replaced in their furnace was not what he said it was. It was a reasonable inference that that was a false statement, and the de Oliveira's relied on that in allowing him to charge them the $500. And when it became clear later that part that he replaced was only worth, I believe, $3.25, that made it clear, and the judge was able to infer that the defendant intended and knew that the statement he made to them was false, that he replaced a firing assembly, which nobody really knew what that was, and it clearly wasn't what he had replaced.
I have some questions about the photograph.
Yes.
So how or why was that photograph relevant in this case to absolutely anything?
Well, I would agree, Your Honor, that it didn't really become clear. The Commonwealth had promised that they wanted to admit it and they would show its relevance later. I agree that they never really did that. So I would agree that it was error in that it wasn't relevant, but that it was harmless error because it didn't, the photo didn't paint the defendant in negative light or show him in any unrelated criminal activity. And it was just clearly not unduly prejudicial to his case.
Is there anything in the record from which we can infer how it might have been relevant? In other words, there was a representation made by the trial prosecutor that we will tie this in. How would they have tied in that photograph? How could that, what issue was that relevant to at trial?
The only thing I can think of is the fact that he was posed next to a motorcycle, and the Commonwealth may have intended to show that the defendant was had financial difficulties. He was kind of in over his head, had bought expensive things and needed the money, and that's why he was overcharging clients. But that really didn't.
I'm sorry. Run that past me again. The fact that he owns a, I mean, it looks like a nice bike, but
yeah.
I have a very, very difficult time tracing the logic there that he was in financial difficulties or that he maintained a generally lavish lifestyle.
No, I agree, Your Honor, and that's why I agree that it was probably it should not have been admitted. It was error to admit it because the Commonwealth really didn't have a relevant reason for admitting it.
There was no plausible pathway toward relevance in any view of the case, was there?
Not that I can see, Your Honor, not from the record as it is, but I stand on my argument that it really it didn't end up prejudicing the defendant's case because of the fact that it really didn't show him.
Right. The prosecutor had an obligation before the judge to have a good faith basis for even presenting the evidence, much less a good faith basis for representing that they would establish a basis of relevance.
Agreed, Your Honor. And it's just it's not clear from the record where they were going with that. So I'm unable to answer the question based on the record as it stands.
Counsel, I saw,
Unlike the other two members of this panel, I am not a former prosecutor, so I don't know what kinds of conversations take place in the district attorney's offices, but this sounds like a good one to have.
Yes, understood, Your
Counsel,
Honor.
I saw in the record, in the pretrial proceedings, there was conversation about the fact that both parties agreed to pre-marking all of the exhibits except for this one. Do we know from the record if there was any motion in limine about this photograph, or whether or not there was conversation about possibly redacting it to, take out the defendant's bare chest, or stipulating that he owned a Harley?
I don't recall right now. I know there were some motions in limine. I just don't remember if this particular photograph was the subject of one of them.
Even that would have required some pathway toward relevance, and I think it's well. Anyway, we've.
I actually have one more question about it, and that's when evidence is admitted subject to a representation that the relevance will be later established. So I guess by analogy, we could say, for example, evidence taken to Bene, and the tie-in is not met at a later time. Whose obligation is it to strike that evidence? Is it the obligation of the defendant to move to strike, or is it the obligation of in this case, the Commonwealth, the presenting party, to raise it before the judge and ask for the judge to do something about that?
I would say probably the defendant, because he would be the one who had the issue with the evidence coming in.
I'm just wondering if that's discussed in any cases. I don't recall any.
I don't know off the top of my head, Your Honor.
Okay.
Unless there are any other further questions on the other arguments, I would rest on my brief and ask that the court affirm the convictions in this case.
Seeing no further questions, the argument is.
All right, we are live and recording.
The next case on our list for argument this morning is case number 2019 P1231, the Commonwealth versus Glenn Christie. You may begin.
Good morning, Mr. Chief Justice, and may it please the court. My name is David Rangaviz, and I represent Glenn Christie. Probation is not a trap. Probationers are entitled to unambiguous notice of the conditions and also can't be violated for actions that cannot be deemed willful. The 356 days that Mr. Christie spent in custody ran afoul of these fundamental principles. This case involves 3 alleged violations of probation, and I do want to try to address all 3 today in the same order that I did in my brief. But before I do, I want to make one point that applies to all 3 of them. Mr. Christie suffers from serious, documented, and ongoing medical issues. You will find records from his hospital admission and visit at Record Appendix pages 123, 131, and 175. There is a letter from his doctor as well, Record Appendix page 189, and a list of his diagnoses and medications starting on the next page. The progress reports from his treatment program, Record Appendix page 155, also repeatedly refer to his medical problems, and he testified to those problems as well. And I'm not just saying this to try to evoke your sympathy. Mr. Christie's medical issues and their severity, they matter because they bear directly on the issue of willfulness. He did not willfully fail to do things that were physically impossible for him to do, but he was supervised by a probation officer who did not account for his medical issues, did not return his calls, ignored his documentation, and showed him really no understanding when she asked for him to spend 2 years in prison for these non-willful allegations. And if I could turn to the first alleged violation, the missed meeting with his probation officer on February 25th. The medical records explain how Mr. Christie lost consciousness on February 22nd, 2019, how he was taken to the hospital by ambulance and seen immediately due to, quote, a high probability or potential for life-threatening deterioration. That's at Record Appendix page 127. He's then kept overnight and discharged the following day. But 2 days later, he's still having issues. He testified that he can't stand up without passing out. He explained at his violation hearing. He called his probation officer twice to try to explain that. The screenshot from his phone is at Record Appendix page 148.
Where
Then he
in the
goes-
record is the evidence that he left voicemails for his probation officer?
I believe he testified that he left voicemails, and I believe he testified that he also sent his husband in person. I think the Ms. Brophy's testimony was that she did not recall voicemails, but
So is the probation officer's testimony that she didn't recall voicemails evidence that there were voicemails?
no, Your Honor, I don't believe that. I was just trying to clarify the full state of the record. No, I don't believe it's evidence that there were voicemails.
So on
But
page 24 of the transcript, when the defendant was asked at the probation violation hearing, did you phone probation? Answer, I did twice that morning. And then they talk about the screenshot. Did the defendant ever testify that he left voicemails?
Your Honor, I may have been mistaken about that. It appears perhaps he did not testify that he left voicemails, Your Honor. But there's also the screenshot from his phone showing that he went the extra step of also calling the probation service at Ashburton Place. So those three calls are documented, and they're also not disputed by the Commonwealth in their brief and their recitation of facts. So his illness
Did he leave voicemails at Ashburton Place?
I don't believe there's any testimony about voicemails at Ashburton Place. But his illness is documented. His efforts to contact probation are documented. And I don't really understand why during a pandemic, the Commonwealth wants to create uncertainty here about whether sick probationers have to go to probation meetings. If there was ever a case for this principle to apply, the idea that a probationer does not have to go to a probation meeting when they're sick, I think it would be in this case. The illness is documented, and the calls via the screenshots are also documented.
Could they be hang-up calls?
Well, Your Honor, I suppose anything's possible. There's nothing in the record about that. But I think one thing that also bears on the willfulness of this mismeeting, as well as I argued in my brief, is that he attended the therapy later that same day, which I think shows if he was sort of someone that was going to blow off his supervision and not show up for any of his probation conditions, presumably he would have missed the therapy session later that day as well. But that's something that I think also reflects sort of the lack of willfulness, because as he testified at the violation hearing, this condition was something that sort of was worse in the morning and sort of improved throughout the day.
If I may, I want to circle back to something you said just a moment ago, because it confused me. You suggested that the insistence that someone who is ill attend a probation meeting during a pandemic, but the violations here all occurred a year before the pandemic, right?
Oh yes, they did.
Okay, so we're not talking about an ill person being compelled to attend a probation meeting during the pandemic.
No, that's correct. But I think the point is that whatever decision this court reaches in this case will apply to others. And
well, if there are questions about people who have missed probation meetings during the pandemic, we will certainly undertake those inquiries. But I don't think the pandemic bears on his requirement to attend a hearing. The question about what efforts he made to alert his probation officer that he wasn't going to be able to attend is a separate one, but it really is unrelated to the pandemic.
Well, I think my point is that this court should rule that sick probationers do not have an obligation to attend probation meetings, and that ruling is especially important and should be made especially emphatically at a time when there's such a great risk from the pandemic. Justice Neyman.
Thank you. It segues, I think, to the issue of the missed sex offender treatment meetings.
Yes, sir.
Sessions. My understanding, correct me if I'm wrong, but I believe your client missed 12 out of 30 sessions. I think they provided information as to why he missed 2 of them, but the reasons that were given at the hearing for missing the sessions included a missed bus, wasn't feeling up to it, and bad weather. So it begs this question, at least for me. Your argument is that here he failed to satisfy, or did not fail to satisfy the term, because the term was, or the condition rather, was completing treatment or completing these sessions. So the question that it begs for me is attending sessions a necessary prerequisite to completing sessions?
Well, One point I would make just parenthetically is that the basis of the violation was the suspension from treatment. So of course the suspension from treatment was partially based sort of derivatively on the missed meetings, but the point I made in my brief is that the question really is a suspension from treatment that is immediately lifted even before the violation hearing enough? But I will go through those 12 missed meetings because I think some of them are.
You can, but I want you to answer my question first, which is attendance at counseling sessions or treatment sessions a necessary prerequisite to completing such sessions?
I don't think that they are a condition of someone's probation, when the condition of someone's probation is, in this case, to have treatment or also to complete treatment. That's not a condition of the person's probation. The condition of the person's probation is to complete the program. And as the Commonwealth said in their brief, that means that things that make it impossible for them to complete would be a violation. So such as a full termination from treatment. But just missing some of the meetings will not make it impossible for him to complete that meeting and result in a violation of probation. But I do.
The concern, and I will let you finish after this, the concern with your argument is the way your argument is set forth, someone could spend 5 years simply missing sessions. Let's say they were on a 6-year probation sentence. And then in the 6th year, start attending sessions, and there would be no repercussions, there's no enforcement mechanism, there's no supervision at all, while your client is willfully ignoring the prerequisites of the condition. Well,
I don't think that's necessarily the case, because I think in that hypothetical, the person would almost certainly be terminated from that treatment program if they're missing all of the meetings and they're offering no justification, and it's a willful missed meetings, as you said. But I would refer Your Honor to the progress reports starting at page 155 of the record appendix, which I also sort of summarize in the record appendix pages 33 to 34 in that table in my motion to reconsider, because so many of those missed meetings are sort of clearly justified even by documentation in the record. The October 15th missed meeting was actually canceled by the program itself. The December 10th missed meeting, Mr. Christie was at Mass General Hospital, which the records are in the appendix. On December 17th, he's in court with his husband, and the docket from his husband's case is included in the record. On January 7th, he's actually in custody. And you can see from the docket in this case, a release from custody order that day. On March 18th, he's in Suffolk Superior Court for his violation hearing before Judge Tochka, a different violation that was not found, that was not substantiated. And the FTR docket notation from that shows that part of the hearing started being recorded at 3:18 p.m. and the group meetings start at 5. And then many of the others, which is sort of why I started with his illness, are things associated with his illness, him reporting that he's not able to get there. The 2 March missed meetings, for example, that he testified to at the violation hearing, he explains by citing the degeneration of his spine that's even continued to the present and had to result in him getting a surgery. I'm sorry, Justice Grant, please.
What is the probation condition? Is it what the judge says at sentencing? Is it what's on the docket? Or is it what's in the probation contract? And if there's a discrepancy between those, which one controls?
It's what the judge says at the hearing, which in this case is in the record page 265, which is to have treatment. And then the probation order in this case was also to complete treatment. And I think in terms of having treatment, I think it's especially probative here because as I cited in the record appendix on page 183, Mr. Christie is also undergoing a separate course of treatment. He's seeing a woman named Vicki Locke for what her letter calls sex offender mental health treatment, and also the certificates of her completion of certain programs in that field are also included in the record. So he's having the treatment that he's been ordered to have. And to the extent that there should be any sort of requirement of more specificity, the SJC has held in a case called Commonwealth v. Delisle, which is not cited in my brief, but it's 440 Mass 137. It basically says that even in the absence of a violation, a probation officer can bring a case forward and have a judge order someone to attend a specific course of treatment. So if there was any issue with the treatment he was doing with Ms. Locke, it certainly would have been fine for Ms. Brophy to bring the case forward and have the judge specify a specific course of treatment, a specific organization that he was supposed to go to. But he's having treatment this entire time. So this is not someone who's not taking his mental health seriously or not having the treatment that the judge ordered him to have when he ordered the probation conditions. And one other thing I think that's notable is that this is a person who's sort of contemporaneous reasons given to the CPC program that are reflected in the progress reports. They're borne out every single time by subsequently obtained documentation. He's not lying to them. He's not contriving reasons to miss these meetings. And I think that's really important because, again, that goes to willfulness. And with my little remaining time, I do want to touch on.
Mr. Rangers, before you do, you confused me again with your response to one of Justice Grant's questions. You said, if I heard you correctly, that if there is a discrepancy between the probation order and the judge's statement at the revocation hearing, that it's the judge's statement that controls. Do you have a statute or a case to support that? I guess I was surprised to hear you say that.
I can provide one after argument, Your Honor, because I do know that
there. On with your other 10 days. Why don't you go on with your other last argument?
Yeah, and just finally, I do want to touch on the GPS condition because the fundamental reason why Mr. Christie didn't violate his probation on this allegation is that he did exactly what Elmo told him to do. His device breaks at 10:30 p.m. on Saturday night. Elmo tells him to appear the next night between 7 and 10 p.m. And he says he'll try to be there at 7, but there's a massive fire that results in shutting down the blue line. And he basically tells them he's running late. He can't find a ride. He'll have to take a bus and a train, but he'll be there in 90 minutes around 9:15. And they tell him, just come to court tomorrow. You have to be in Suffolk Superior Court anyway and just get a new device. And that's exactly what he does. So the Commonwealth's theory of this violation, it has to be that Mr. Christie's estimate of when he would arrive at the Quincy Police Department the following night, 7 p.m., somehow became a binding condition of his probation. But of course, that can't be so. There's nothing in the probation conditions that says that. There's nothing in the GPS conditions at Record Appendix page 83 that says that. And in its amicus brief in Feliz, the probation service itself described these after hours shifts as options, as matters of convenience. But Mr. Christie did everything he could do to get to Quincy. He ran later than he expected due to an unforeseeable fire that shut down public transit. And he did everything Elmo told him to do to get the device fixed. That is not a violation of probation. Justice Neyman, I'm sorry.
Chief Justice Green. Thanks. Assume for the sake of argument that we agree with you that the information or evidence was insufficient as to one or two of the three violations, but we disagree with you and think it was sufficient as to, again, one or two. What is the correct result then in this case, and what authority do you have for your answer?
Well, the correct result would be to move on to the dispositional issue that I raised and for the court to consider whether further incarceration beyond the year Mr. Christie's already served would be an abuse of dispositional discretion in light of the violations that the court thinks are substantiated. But if the court doesn't agree with the dispositional argument that I've made, then the proper thing to do at that point would be to remand for resentencing based on the actual violations. And the support I've cited for that is in footnote 25 of my brief, which is Commonwealth versus King, which is a case from last year, this court written by Justice Wolahojian.
Thank you.
Thank you. For the Commonwealth?
Morning, Your Honors. May it please the court, Kayla Johnson for the Commonwealth. And I'll kind of go through the violations in the same order that defense counsel did here. So first I'll start with the misprobation meeting. And here, as is made clear, and for the other violations as well, it's not disputed that the defendant had missed this meeting with probation or missed these the meetings for his sex offender treatment. And in particular, for this probation meeting, the defendant testified that he was hospitalized prior to this meeting. And I think it's important to note to the court that the defendant did not call his probation officer until 10:30 on the morning of the meeting when he was supposed to be going in to meet with his probation officer, where he had knowledge that, and he knew that he had health problems that were going to be particularly affecting him in the morning. And he did not communicate that with his probation officer prior to this meeting.
Counsel, can we tell from the record, was there a specific time for that meeting on that day?
I went back through and I don't think the record indicates what the specific time was for that meeting. But I think it's still important to note that the defendant didn't call his probation officer until kind of the middle of the morning on that day, although we're not sure, or the record doesn't reflect exactly what time that meeting was going to be at. And I think, as I mentioned, the defendant did have ample opportunity to communicate this to his probation officer, and he did not do so in this case. And I think, again, that's especially important to note where the defendant did testify that he knew that mornings were problematic for his health. And I think another important thing to note is that the judge in this case had all of this information before her. She not only had the testimony of the defendant's probation officer that he did miss this meeting and that she did not recall whether she had any voicemails left on that morning, but the judge also had the information that the defendant was experiencing these health problems and that he was hospitalized prior to this meeting, so to the missed meeting. So I think the fact it's important to recognize that the defendant provided this information to the judge, and the judge nonetheless found that this still was a violation of the terms of his probation where he missed this meeting, and that this was indeed a willful violation of the requirement that he go meet with, or that he meet with his probation officer that day.
But the fact that the judge reached that conclusion, isn't that what we're here to review?
Yes, Your Honor, and I think it's important to note all of these factors because this court is here to determine whether the information provided, whether the judge abused their discretion in making this determination based on what was provided at the hearing here. And I think all of the evidence bears out that this was certainly not an abuse of the judge's discretion to determine that the defendant violated this condition. And if there's no further questions on this violation, I'll move to the defendant.
I do have one brief question, and that's since the defendant did testify, was the judge obligated to make credibility determinations? I mean, another way of saying this is, had the judge simply said, "I've heard your testimony, I don't credit it for the following reasons," this might be a far different case. We don't have that here.
No, that's correct, Your Honor. And I think it was within the judge's discretion to make a credibility determination, certainly. And while we don't have whether the judge specifically credited or discredited the defendant's testimony, I think the fact that it was the defendant himself testified to the circumstances behind these alleged violations, and the fact that the judge had all that information in front of them is important, because without that information, and again, although we don't know for certain, the judge didn't explicitly say whether they discredited or credited the defendant. I think having all this information makes very clear that the judge clearly exercised their discretion based on the information that was provided to them, and that in exercising their discretion, they made the appropriate conclusion here. And moving on to the significant absences from his sex offender treatment, I think again here it was certainly within the judge's discretion to make the determination that this repeated absence from his sex offender treatment, which in the period of, I think it was 8 or 9 months, that there were 12 missed meetings. And again, I think it's important to note that the defendant did provide the reasons for why he missed these meetings. That he testified to 2 of the meetings and where he missed the meetings without notice, and the records from the counseling center were provided to the judge.
What was the condition of probation at issue here?
To complete sex offender treatment. And I think
I suppose at any point before completion, regardless, even if you have perfect attendance, at any point before the program is completed, you have not satisfied that condition. But that, of course, would not be a violation, would it?
That's correct, Your Honor. And
when does that condition of probation stand as a violation? Serve as the basis for a violation.
Sure, and I understand the point, and I think this case kind of highlights that point. I think when there is a period, an extended period, where the defendant was missing sometimes more than half of his monthly sex offender treatment sessions, I think that certainly not only would that give notice to someone that they were not doing what they needed to do in order to complete their sex offender treatment. I think in this case, in particular, where there was evidence that he had been spoken to about this problem prior to the suspension being initiated.
As you've heard your brother argue, it's open to the program provider to terminate rather than suspend, or to terminate rather than to allow him to continue with a stern warning. That neither of those took place here. You know, I understand that the chronic absence is a problem, but it seems to me the mechanism lies with the terms of the condition, not the and also with the provider to terminate rather than suspend, right?
I don't, Your Honor, respectfully, I don't think that the distinction between suspension and termination really matters in this case. I think what the judge was really focusing on was the fact that this was a repeated pattern of missing these treatment sessions. And I think that is what was important to the judge here.
We know we can infer, I suppose, again, we don't have an explanation. We can infer that the judge was animated by the chronic absences. I'm focusing more on a question of law, which is the nature of the condition and what constitutes a violation. And I guess I'm having a little, speaking for myself, I'm having a little difficulty squaring the condition itself with the finding of a violation.
It's a fair point, but I think I would say that in this case where the defendant had missed so many treatments, I think that is clearly not consonant with behavior that would allow him to complete this program. I think in order to complete a program, you need to actually attend and participate. And for an extended period, the defendant was not doing that.
Was there evidence from the probate testimony or other evidence from the program provider to substantiate that description you just offered?
As to
the relationship between the degree of absences and the ability to complete.
I don't think there were specifics, but I do recall.
What was there?
I do recall in defense counsel's motion to reconsider that there was information about how there was a distinction between suspension and termination, and that there needs to generally be maybe a prolonged period of
I'm looking not at argument. I'm looking for evidence that would substantiate a conclusion that the condition of probation was violated as a matter of law.
I think the evidence that we have here is that he missed the meetings, and I think that that's not consonant with completion of the program. Yes, Your Honor.
No, that's what you think. I'm just asking for evidence. I see that Judge Grant has a question.
This is back to one of my questions to Attorney Rangavis. If Judge Drexler said at the plea that the condition of probation is to undergo sex offender evaluation and treatment as deemed appropriate, and that's what's noted on the docket, but then the probation contract says complete sex offender treatment, what is the condition of probation, and is the defendant on notice of that condition, and when has he violated it?
And Your Honor, I meant to bring this up. I don't know the exact answer to that question, and it's something I would also be happy to follow up with to the court. I'm not sure how it works, if both parties would be able to submit something on this issue, but I'd certainly be happy to look into it and submit something to the court on the issue, because I think it is something that would have bearing here, particularly where we're looking at the terms of the condition and whether they have been violated.
So I'd like to ask you the same question I asked your brother as well. obviously very balanced here today. So suppose, again, hypothetically, suppose we agree that the evidence was sufficient to establish one violation, but insufficient to establish the other two. What is the correct result, and what's your authority for the proposition?
Unfortunately, off the top of my head, I can't think of a case to directly point to, but my understanding would be that as long as there is evidence to support one of the violations, that would be appropriate and would be within the judge's discretion to revoke the probation based on one violation.
No,
and again,
I accepted that argument in a case called Commonwealth versus Arroyo. I was in a majority with Justice Barry, and Justice Mills authored a dissent, and turns out the SJC didn't agree with us.
Oh, I apologize, Your Honor. I wasn't aware of that case.
Arroyo is cited in the King case that your brother included in his brief, but Arroyo was the place where, and actually it doesn't even matter if one from a distance could look at the violations as being more or less material. Here, it's not clear to me that you could rank order the significance of the violations in any significant way, but as I understand it, that's our law.
I apologize, Your Honor, for the mistake there. Like I mentioned, I wasn't sure about case law on this issue in particular. But I would say, I think, as I argued in my brief, I think even if the court was to look at the sentence imposed or to remand, I think that the sentence imposed by the surrender judge in this case was within the reasonable range of alternatives based on the violations. And I think the judge specifically noted their particular concern about the missed sex offender treatment meetings. So I think that was something that was significant before the judge. And I think finally, just moving to the last violation very briefly, I realize I'm running low on time. But I think it's important to note to the court that the defendant himself said that he was going to appear at the Quincy Police Department to have his GPS monitor restrapped on the next day after it had become unstrapped. And the Elmo had to contact him twice after 7 o'clock when he was not there. And even after 7:40, the defendant himself said he still was not, he was still at home, and it was going to take him a significant amount of time to get there. So at that point, I think after the defendant had told them that he was going to be there at 7 o'clock, they appropriately determined that they were going to issue a warrant for his arrest and that he should go to court the next day to have it restrapped. And I think it was, again, within the judge's discretion here to determine that he failed to have his GPS monitor restrapped when he was explicitly told to do so and said when he would be there. And if there are no further questions, Your Honor.
Seeing none, that will conclude the argument in this case. The case is submitted. I neglected to mention to those watching on our YouTube stream that we will be taking our mid-morning recess at the conclusion of the argument of this case. We will resume at 11:30. All right, our next case on the list for hearing this morning is case number 2020 P898. This is an impounded matter. It involves a termination of parental rights. For that reason, I have admonished counsel on both sides to refrain from referring to any of the names of the parties. With that, Attorney Kane, representing the mother, you may begin your argument.
Thank you, Your Honor. Mother is asking for remand on this case based on DCF's failure to make every reasonable effort to reunify mother with her daughter, and on the trial judge's erroneous finding regarding the same, which was finding number 170. There is no doubt that domestic violence was the main issue in this case. Mother cared for her daughter from birth to age 2 with glowing reviews from the department. A was always clean and appropriately dressed. The apartment was always clean and appropriate. A was bonded to her mother. Mother cared for A appropriately and effectively. Mother was very caring and affectionate. And A's pediatrician never had concerns, nor did her daycare. DCF's main concern was the domestic violence perpetrated by father on mother, and this was a legitimate concern. Yet despite this concern, and its mandate to make every reasonable effort to ensure that mother and daughter could remain together, DCF let 10 months pass without recommending a specific domestic violence service for mother on her action plan, which were formerly known as service plans. DCF only referred mother to therapy. And when DCF finally added a domestic violence service on mother's action plan, it was 5.5 months after A was removed. The service DCF offered was simply a referral to, quote, re-engage with New Hope for DV services.
Attorney Kane, before you continue, since you're arguing DCF's failure to make reasonable efforts, it obviously begs the question, how and why is this issue before us? As you can see, and I acknowledge that you were not trial counsel, but as you also acknowledge in your brief, this issue was not properly preserved for appeal because it wasn't raised below. That's my understanding, or at least it wasn't explicitly raised.
Correct, Your Honor.
So I just want to make sure I'm understanding that point. And am I correct? I did a search. I don't see the words reasonable efforts referenced anywhere in the transcript or in the exhibits for trial. Am I correct about that?
Your Honor, I didn't do that specific search myself, but you're correct that it was not explicitly raised, although mother argues that reasonable efforts is always an issue before the trial court because the department is required and the judge is required.
An obligation.
Right, and the judge did made a finding specifically that the department made reasonable efforts. But the reason why I would argue why this is appropriately before this court is I would ask this court to take a close look at RH versus BF, which is a case that I cited in mother's reply brief. And that was the appeals court decision that led to custody of Vaughn. And in that case, the appeals court decided for the first time that judges were required to make specific findings regarding the effects of domestic violence on a child. And the appeals court found, and this is a quote, that it was open to the appeals court to provide guidance on the issue of how domestic violence should affect any decision, end quote. And that's on page 41 of RH versus BF. And in that case—
about that.
Sure.
When the appeals court decided RH versus BF, and then as I understand it, the SJC took the same case in custody of Vaughn and decided it and issued its opinion. Is the appeals court's case still good law?
I would argue that it is because that's the same, it is the same case. It was just renamed to custody of Vaughn, and what the SJC said was that they affirmed the lower court's decision in that case. So I have
to put too fine a point on it, but the technically, while the Supreme Judicial Court reached the same result, affirming the decree of the lower court, when the SJC takes one of our cases and rules on it, their decision, their opinion obliterates the effect of our case. And certainly, you're entitled to look to the reasoning and expressions in the appeals court opinion for persuasive effect, and also the SJC opinion did rely on some extrinsic materials in reaching that same result. However, the holding in custody of Vaughn and in RH, in fact, substantiates the conclusion that the trial judge in this case found, which is that the effects of domestic violence on a child are very worrisome. You are asking us to go in a distinctly different direction in a couple of different respects. What you're asking us to do is to follow that same methodology to enter a new requirement that requires, even in a case where it's not raised, that the trial court examine with close scrutiny the degree of efforts that the department has made, and I guess separately, the materials that are the subject of a motion to strike in this appeal that are, you concede, outside of the trial record. Look, there is no question that social science materials pop up from time to time in appellate opinions. My question to you is, had you or your predecessor counsel offered those articles in evidence at the trial of this case, would they have been admissible? And if so, what hearsay exception would they have met?
So if trial counsel had sought, probably the most effective way for trial counsel to submit such information would have been through calling an expert on the issue.
Okay, so that's not the most effective way. That's also the permissible way under our law. And yet you are asking us to take material that is not only outside the record, but not admissible, hasn't been tested by cross-examination at the level of appeal in order to pronounce a new rule. And I guess just speaking for myself, that's a heavy lift.
Your Honor, I would argue that it's the same thing, though, that the court did in RH versus BF. They looked at the gender bias study, they looked at a book, they looked at a couple law review articles, and I don't think that there was any evidence to suggest that those were submitted at the trial in that case either. So Mother argues that that case persuasively would also allow this court to consider similar information.
Whether we have the authority, I suppose, is a different question than the one of whether this is an appropriate vehicle for us to exercise. And I guess I would also just observe that at least in RH, one of the most central element of the basis for the court's conclusion was a recently concluded study by the court itself, by our Supreme Judicial Court, and not a series of untested social science articles by authors of unknown provenance.
Well, Your Honor, I would also refer the court to the Nicholson versus Williams case, which I realize is not a Massachusetts case, and was a class action, but there are no similar cases in Massachusetts, which is why I was referring to which courts do look to outside jurisdictions when there isn't specifically a case on point. So there is the Nicholson versus Williams case as well.
I understand, but there are also, look, your comment in your argument in your brief about how pervasive a concern this is and how important it is that we provide guidance. I mean, I don't mean to dispute the significance of what it is that you're asking us to do. If anything, it seems to me all the more reason why we ought to have a proper foundation on which to undertake that inquiry, and not to do it on an issue that was not joined at trial, on the basis of evidence that was not presented at trial, and in any event would have been inadmissible had it been presented.
Well, I'm resting my argument. I understand what the court is saying, but I'm resting my argument on the RH versus BF case and what the court did in that case, and also on the Nicholson versus Williams case. And I know that you said that this would be, Mother is asking for this to be a second requirement for judges to consider in domestic violence cases. Not that it overrides the best interest of the child. Of course, the court would still look at both issues, and the best interest of the child is always paramount. However, it is in the best interest of children that their parent victims of domestic violence are offered the right services.
I've been at this long enough to know that for an issue of importance, the right case will come along, and when that right case comes along, there is an opportunity to develop the factual record in order to provide the appropriate answer. But we have a number of laws, a number of principles that urge caution on appellate jurists from reaching farther than they ought in a particular case. Rightness, mootness, exhaustion, actual case or controversy, completeness of the record. And I will also confess to you that every time I have reached for an issue because it was interesting on an inadequate foundation, subsequent events caused me to question the wisdom of my analysis on an incomplete foundation. There's a certain humility that sets in after a while. That's all I'm saying.
Well, I would certainly obviously respect that you have been doing this for a long time and on that issue. But I do think that domestic violence is one of those issues that is problematically misunderstood, which is why attorneys maybe weren't asking for this service at the time, why DCF wasn't maybe even itself knowing to offer the services. I'm not saying DCF knew this was the most critical and beneficial service and intentionally didn't offer it. I think it's just misunderstood issue. And as we see from judges, that there's this victim blaming. Why didn't you leave him? How could you go back to him? Without really understanding the cycle that's involved there. And given that this affects not only the child in this case and the family in this case, but in so many cases, unfortunately, there's a lot of domestic violence in our cases, that it's important for this issue for judges, for attorneys, for parents to have direction on how should this be addressed and how can we do this better.
I have a question about this. Let's assume we could turn back time and mom's counsel at the hearing gave Judge Souza all of the articles, social science articles that you're now relying on, and Judge Souza read them all and was completely educated about this area of domestic violence, including the view that in-house domestic violence shelters with in-house services are the best way to give people domestic violence counseling. On this record, where the mother testified that when she did go to the Seeking Safety group at High Point, she only went because it was requested of her. She didn't complete the class. She didn't feel like it was beneficial to her at the time. She didn't feel like she was a victim. She felt like it was not necessary. Couldn't the judge still have concluded, and DCF still have concluded, that the DCF had made reasonable efforts by what they did do when the mother refused to take advantage of it, and that offering her an in-house DV program was not required for the efforts to be reasonable?
So, Your Honor, if you look at from when those statements were, she was referring, I think that was back in 2017, very early in the case. And that is exactly what the literature says that you can expect from a lot of victims of domestic violence, is they don't know they're the victims of domestic violence. So it's why they're stuck in the awful cycle that they're in. So that's not surprising that mother was saying that early on in the case, and also not surprising that she was saying it without the most critical and beneficial service. But if you look at by the time of trial, mother was doing a lot more. She had been in therapy. She completed a parenting class. She was attending a women's trauma and abuse group every Friday and had been for 5 months. So I think there was evidence that mother was engaging in the issue and working on the issue. So I think it's twofold in that is what you would expect from these moms early in the case. And it shouldn't be a reason not to refer them to the most critical and beneficial service that they can use to get out of the situation that they're in.
See that you're running out of time. Is there anything that you would like to press on us in your remaining 40 seconds?
Your Honor, at this point, I would just rest on my brief, but again, stressing that, this is an important issue that affects a lot of families that I work with and see in these cases. And I think it's an important issue for this court to address, just like the court did in RH versus BF.
Certainly, we are all too familiar with the pervasiveness of domestic violence and recognize its importance.
Thank you, Your Honor.
All right. Are we hearing from the department first?
Yes, Your Honor.
Okay, Attorney Bayless.
May it please the court, Jeremy Bayless for the Department of Children and Families. As Your Honors and my sister have acknowledged, this is a difficult case, as are all the cases with long-term sustained domestic violence. There are several reasons why this is not an appropriate case to, without it being preserved below or raised in any detail, go into a structural analysis of domestic violence concerns for parents at a 30,000-foot level, because in this case, the mother had not made the appropriate, had not taken steps to benefit from the services that were provided to her. In 2017, my sister and Justice Grant are correct that mother was testified that she did not feel that she was a victim of domestic violence. However, in the intervening 2 years after that, she was engaging in domestic violence treatment with her therapist, and she was beginning to go to some programs, and yet she was still inviting father to her home in Rhode Island in 2019. She was going ice skating with him. She was maintaining a relationship. And while it may be the case that there was some other program at some point in this process that, were it available and were it provided, there might have been some change. That's simply impossible to evaluate at this level. Mother doesn't identify what long-term residential program would have been available, would have been able to take mother, because, as your honors are aware, a major challenge facing the department and services in child welfare cases in general is that there's just a limited amount of programs available and a limited amount of space. It's a challenge with daycare services. It's a challenge with getting people into residential treatment for drug abuse, for all sorts of services. Without, I guess the simplest way to put it is, we might be able to evaluate whether or not this parent and this child would have been positively impacted by a long-term residential program if it had been raised below the way it is contemplated by Gregory, where either mother or her trial counsel files an abuse of discretion motion or simply calls or emails the social worker saying, I've found this program, I think it will help. And then there could be an analysis of, there are X number of beds at this program. They can take it, they can take her, they cannot take her. These are the rules of the program. Mother spent years violating the rules of every shelter she stayed at. She invited father to the shelters. She engaged in fights and arguments with her neighbors at the shelters, including causing her to be arrested. She broke curfew, even when it was court-ordered curfew. And she didn't maintain her residence clean, not in the sense of scattered clothes, but in the sense of puddles of blood and needles, or safety pins, not needles, and scissors on the ground within reach of the young child. We can't evaluate whether or not this would have helped. And if anything, looking at the way mother behaved in the services that she was referred to and in the shelters where she was sent to live, the evidence would indicate that if we are forced to speculate, that the assumption would be that mother would not have taken it seriously. She would not have followed the rules of the programs, as she did not follow the rules of less restrictive programs for the years prior to this case. Mother was offered a number of services to address domestic violence. This provision of those services and whether or not they were enough was not challenged below, and evidence was not presented to the judge such that they could make an appropriate determination.
How would you characterize the emphasis or the focus of the mother's case at trial? What was the theory? Just simply that DCF didn't meet its burden?
That is my recollection, yes. And in addition to the domestic violence piece, there was also ample evidence that mother was not providing a stable household. She wasn't providing safe, stable housing in terms of maintaining, a clean and safe home. She was herself engaging in violence at times in front of the child with neighbors. She did stab father in the neck with a knife. It's not entirely clear because there was conflicting testimony as to whether or not that was a defensive or offensive action. Mother testified that father, in essence, stabbed himself with the knife by lunging at her. But this child was not in a safe environment. And as 29C contemplates and Ilona describes, even if the department had erred, which it in no way concedes, but even if it had been an unreasonable omission to not provide this sort of service, the court was required at trial to make the determination as to what was in this child's best interest. And the evidence was clear and convincing that that mother was unfit, which she doesn't dispute, and that the termination of her parental rights was in the child's best interest. And if there are no further questions, I'll cede the rest of my time and rest on my brief.
Thank you. For the child?
Richard Schokeier for the child, and may it please the court. The child's position is concise. It's in line with the department's position. The child asks that this court affirm the lower court's ruling, terminating mother's parental rights, freeing this child for adoption. Mother is unfit. She repeatedly placed the child in harm's way. Her history as both the victim and perpetrator of domestic violence goes back to 2006, with her first of now 4 children who are no longer in her custody. Time and again, she failed to live up to her parental responsibilities and placed the child at risk of serious harm. Prior to and throughout the proceedings, mother actively sought to perpetuate a dangerous relationship with father. Her behavior was systematic and it was intentional. She modified restraining orders. She testified at father's behalf at his parole hearing. And as Attorney Bayless mentioned, in early 2019, just 3 months prior to her own termination trial, she provided him with her address and harbored him in Rhode Island, where he was arrested, just as she did at the beginning of this case at the shelter. Her objective actions spoke to the court, where mother said, "I am not going to end this relationship." Furthermore, the appellant does not really challenge the lower court's 253 findings as erroneous. Instead, she proffers one sole issue on appeal, which is if the department, on its own initiative, did not exercise its clinical judgment in making a particularized referral for service, it hasn't made reasonable efforts. And the proposed remedy would be remand over an issue that was never before the court in the first place. This is a flawed argument, procedurally, substantively, and constitutionally. Mother never raises the argument at any time. She, as Attorney Bayless said, could have sent a letter, hired an expert, participated in action plan negotiations, or filed a motion for abuse of discretion at any pretrial stage. All of these avenues would have given notice to the department so that they could meaningfully address the issue, or alerted the court so that it could evaluate the claim. This never happened, and it is addressed in my motion to strike. The issue was not preserved and is therefore waived. Substantively, the trial court did do a reasonable efforts analysis, noting that the Department of Children and Families placed the child with mother at the beginning of the case, provided mother with referrals for housing, for counseling, for substance abuse, and for domestic violence. Furthermore, under both care and protection of WALT and Chapter 11929C, even if no reasonable efforts were made, the health, safety, and overall welfare of the child are the paramount and effectively the superseding concern of the court. And this is reserved to the judge's discretion. However, this is not the case here. The court made detailed findings of reasonable efforts, so there is no plain error. Furthermore, mother's contention that this is some exceptional circumstance simply isn't so. There is also no analogous case that is cited to make this an exceptional circumstance. Mother cites adoption of Florida and adoption of Terrence, but these have to do with attorney misconduct. She also cites care and protection of Georgette and guardianship of VV, but these are procedural issues that became moot, but were repetitive and escaped judicial review. This case is not adoption of Larry. It is not care and protection of Isabel, where in those cases, the mother took aggressive and concrete steps to separate from her abuser. And furthermore, there was no collateral evidence that any contact with the abuser followed the separation, as is not the case here. Mother failed to provide any substantive issue to determine, and therefore the judge didn't abuse her discretion and did not commit clear error. Finally, mother is inherently asking this court to act as a legislative body to create some new rubric or theoretical law concerning domestic violence cases. This is, however, analogous to care and protection of Isaac and care and protection of Jeremy, as it is a separation of powers issue. The court cannot order the department to create services on its own initiative without a finding of arbitrary or capricious behavior. Administrative remedies were available throughout the case and were not utilized. And mother cannot simply now tell the department how to do its business where the department has clinical discretion. If I may close, this child's best interest is to remain in her pre-adoptive home, where she's now lived since August of 2018 and recently celebrated her 5th birthday. And over this more than 2.5-year period, she's developed very strong, very loving, and now unbreakable bonds with her pre-adoptive mother, her pre-adoptive father, and her new siblings, who she identifies as her family. If there's no further questions, I would rest on my brief.
Seeing none, that will conclude the argument in this case. Thank you all, and the case is submitted.
Thank you, Your Honor.
No one ready to go?
All right, we are now live and recording.
We reached the last pair of cases on our argument list today for hearing. These cases are paired for argument. Cases number 2020P104 and number 2020P365, Michael R. Boyer versus Jacqueline Boyer. Mr. Trundy, you may begin for the appellant.
Thank you, Chief Justice and Justices of the Appeals Court. May it please the court. I am not going to rehash in detail the briefs which are extensive on both sides. I do want to clarify one particular point in the history of this case, which I think is pivotal and important to understand. This was a complaint filed, although in the probate court, it's a civil complaint under the Mass Rules of Civil Procedure. It was filed in April of 2017. In February of 2019, after 2 years of process discovery, 2 days of depositions of the defendant, an amended motion was filed. A motion to amend was filed, and that's the key document we ask you to look at, the amended equitable complaint at page 46. And at that point, it was argued before the trial judge on March 5th. And at the same time, in response to that motion was defendant's motion to dismiss for some subject matter jurisdiction. That was also heard initially on March 5th. March 5th was scheduled to be, and it was one of, I guess, many dates. I was not trial counsel, but it was scheduled to be the first day of trial. Trial did not start until April 30th. So on March 5th, the very experienced probate judge was aware of the contest to this complaint, which sets out a request for money damages and a thin veneer of facts, which I would just suggest would not have met the standard in the Superior Court for basic pleading as to at least part of this. At that point, the plaintiff was adding a second tort claim outside the jurisdiction of the court. The trial judge took the motion to dismiss for subject matter jurisdiction under advisement and began the trial almost 2 months later at the end of April, and which spread out over time with a little bit here and there. It is our position that, and ultimately, of course, we know that he dismissed 2 of those counts after trial. It is the appellant defendant's position that a trial judge forcing a litigant to answer at trial 2 counts that the court knows it has no jurisdiction of is a fatal defect to that proceeding. That it's
How so? I have to say, I honestly am deeply confused how you can claim prejudice in the trial of 2 claims that you won.
Because the defendant is forced to try cases that it knows the court doesn't have jurisdiction of.
Okay, but I want you to go back and I'll ask the question again because maybe you didn't hear it. You are claiming prejudice on, let me first state, I guess, my operating hypothesis, which is that the probate court clearly has subject matter jurisdiction over an equitable claim of undue influence. The fact that maybe you incurred some additional expense, and for that it's unfortunate. But I fail to understand how the disposition of a claim of undue influence is, how your defense of that claim is prejudiced by the necessity of trying claims that lie outside the probate court's jurisdiction.
Well, it clearly, first of all, I do not think you should have to show prejudice when a court forces you to trial on claims that it has no jurisdiction of.
Do you have any authority
I don't.
for the suggestion that in a civil case, you can claim structural error for an error that causes no prejudice?
No, I don't. But I think that
I'm not aware of any either. It seems to me that if you're seeking a remedy, if you're seeking relief to disturb a final judgment, you're going to need to show prejudice of some form.
Well, I don't think it's necessary to show prejudice just because of the nature of the process, that you're answering to a process that you know that the court does not have any jurisdiction on. That places certainly both counsel in an awkward position. I don't concede the fact that as of the amended equitable complaint, the court had a cognizable claim of undue influence.
Let me come at this, I guess, in another way, because of course the question of subject matter jurisdiction divided among the several departments of the trial court is one of administrative convenience, largely in our era of a consolidated trial court. Under the provisions of Trial Court Rule 12 and Chapter 211B, Section 9, there is wide latitude, even where jurisdiction is non-existent, subject matter jurisdiction is non-existent, to cure jurisdictional limitations by a cross-departmental assignment. And that can be done even after the fact. There's a case, St. Joseph's National Polish Church, forget the name of the lawn care company that was on the other side of the V in that case. But I have some experience in this from going back to my days as a trial judge in a very narrowly defined jurisdictional court. Again, you won the 2 counts that you're saying you shouldn't have had to try, but even if you had tried those and lost them, there is a vehicle, except in extraordinary circumstances, to cure those kinds of jurisdictional defects, unless there is a reason. The Sherwin-Williams lead paint case that was presented to the housing court is the other end of the extreme. We don't want the housing court trying class action personal injury cases. But anyway, I'm sorry, I'm taking up a little bit more time, but you see where I am on this.
No, I understand completely, and this is really the nub of the entire appeal. Everything flows from this. It flows from the standard, what these litigants understood was the claim against them. And when you go back to the amended equitable complaint, which is 3 pages long, 1.5 pages of allegations, it does not set forth a whole series of things in terms of relief that later become an issue. What it does is it simply says we're looking for money damages, and money damages are not something the court should do. Now, in this particular case, there are a couple of things that I think are significant. One of which is that the judge, when he takes this matter, knowing that he's holding on to 2 tort claims that he has no jurisdiction of, it creates an appearance on the part of the defendant that he's got to find some way to move forward to a claim. And which does get you to this issue that I have briefed about the nature of the undue influence here, which is a 3-year plus generalized claim of undue influence with no specific actions and this broad brush damages equation. But in terms of actual prejudice, there is, you can see from, for example, the appellee's brief, which relies repeatedly, and I don't know how many times this is reiterated, that says the defendant did not take the stand, and that is an element to prove the undue influence. It's relied upon because there's so little evidence, quantum of evidence in support of the undue influence, any direct evidence or actions. And that, in fact, despite the fact that the she participated, was available to be called by the other side. The other side offered her deposition testimony. A defense lawyer handled in front of a judge who won't say whether or not he has jurisdiction or not would probably be engaged in malpractice to put their client on the stand and have them routinely cross-examined in a case that may be meaningless. I'm sorry.
I have a question.
Sure.
If this case had gone to trial only on if the complaint from the beginning had read only undue influence and there had never been counts for conversion or intentional interference with an inheritance, wouldn't much of the same evidence have to come in anyway to show the amount of the damages for the undue influence?
My response to that, not being the trial attorney, is, and I can only imagine what it's like I have never been in a case where a judge has forced me to try a case where there was no jurisdiction. But it seems to me that you have the essence of this complaint and the essence of the findings is of a pattern of conversion and or larceny. And so we all know in trying cases that there's a major thrust to a case. And we defend the thrust of the case. The thrust of this case was conversion. So we have a defense lawyer dealing with conversion. If the case is more pointed, I think it makes a difference.
But I think Justice Grant's.
Go ahead. Go ahead, Justice Neyman.
I think Justice Grant's question is, assuming that there was only one count in this case, that count was regarding undue influence, and that's it. Wouldn't the information regarding the underlying facts of conversion and the additional underlying facts regarding the other claim, wouldn't all those have been admissible in a trial involving the issue of undue influence?
I don't know the answer to that, honestly. I don't know how that would change. I do know that the big item I can point to in terms of tactical or strategic lawyer decision was not to put the defendant on the stand in a case that he thought that had no jurisdiction, and he was correct, at least as to 2 out of 3 of the claims.
Well, no, but the undue influence did have jurisdiction. There's no question about that. And whether he puts the defendant on the stand or not on that claim is a question of strategic significance. But I guess to go back to my question regarding prejudice, it seems to me that for you to establish the need for a remedy by being forced to go to trial on these extra jurisdictional claims, you would need to show that there was evidence that was admissible solely on the extra jurisdictional claims that was detrimental to your client's cause on the undue influence claim. And I guess if it was detrimental, it would have been relevant and therefore admissible. I'm struggling to understand on what basis the trial, other than the fact that the trial may have taken longer and required a little bit more expense, but that does not give you a right to a new trial or a reversal of the decree.
Well, I'm not claiming the issue of damages in terms of legal fees or anything like that. The essence of the argument remains that it is unfair to a litigant. It impairs the right to counsel to force a lawyer to try 3 counts where a judge knows he has no jurisdiction on 2 of the accounts. And there is a colorable claim and still remains when you read the amended equitable complaint, which the reason I highlight that is because this is a pleading that relates to undue influence, which has a heightened pleading standard that was pled 2 years into the case. And
I'm going to ask you this question. I think I know the answer to this question because if you had one, you probably would have included it in your brief. But are you aware of any case in Massachusetts decisional law that stands for the proposition that a party who wins extra jurisdictional counts at trial may claim prejudice, may vacate a count that was within the court's jurisdiction without a claim of prejudice?
I'm not aware of any case where a at least recently, where anybody, since these rules have of transfer between Superior Court or anything where anybody has done that.
Well, I think there are lots, we see them all the time where there are cases that are tried in specialty trial courts that lie outside of that court's jurisdiction, and where they are, we vacate the decree if there is a decree. Here, you won those counts.
Well, I don't think that's fair, because all that happened was they were dismissed from the probate court. They were not. There was no winning, no exoneration. The problem is that particularly when you're in this circumstance where you're trying a case where jurisdiction is not fully vested in the judge, that judge is also the trier of fact. And the problem with that, I think, is it creates inferences that the trier of fact is not going to be fair to the party who should not be fully there.
Okay, Justice Grant had a question.
How can we determine prejudice without a trial transcript? For all we know, there was only very brief mention of the extra jurisdictional counts at trial, and the overwhelming stress was on the undue influence counts.
Well, first of all, we did not. I'm sorry, my time.
You may answer. You may answer.
We did not obtain a copy of the transcript, in part because of the urgency we thought of getting this case to the appeals court. However, I do think you can establish that from the record, it is well established that Attorney Coyne, the trial counsel, did not call his client to the stand, which is a keystone of the decision here, despite the fact you will see in the record huge amounts of testimony from her that was derived from her deposition transcripts. So that's an important part of the judge's ruling on undue influence.
I think we have your argument, and we'll have to leave it there. And of course, you can rest on your brief regarding the argument on the denial of the stay.
Thank you.
All right, Attorney Tierney.
Chief Justice Green, Justices Neyman and Grant, may it please the court. It is my client's position that with respect to the appeal of the denial of the stay, I believe the panel should be aware of the fact that the house has in fact been sold. So it would be our position that that appeal would in effect be moot. We don't believe that it's the kind of issue which would be easily, capable of repetition, but evaded in review. So it would be our position that that 0104 appeal should be moot. With respect to the appeal on the substance, we certainly agree with the statements that have been made that the probate and family court did have subject matter jurisdiction of my client's claim that his sister had exerted undue influence over their elderly father. And in response to an argument that was made by Attorney Trundy, when you review the amended equitable complaint, I would request that Your Honors look at the introductory portion of the amended complaint, which did in fact ask for recovery of monies and properties of the decedent, which the defendant sister had unduly exerted influence to have the father dissipate, and that she herself, the evidence showed, had engaged in dissipation.
Your use of the term dissipate is interesting to me because it's, as I was reading the judge's findings in this case and the analysis of the case, this looked to me much more like a case of a claim of dissipation of the estate than a claim of undue influence. The undue influence typically involves someone who is in a close position of trust and confidence, who insinuates themselves into the affairs of the decedent or the ward in a guardianship situation, and causes them, induces them to take actions that are otherwise to be unexpected outside of a natural disposition. Here, the claim is that that she was taking monies without authorization, and that it was basically a malfeasance rather than an influence, that without authorization, without knowledge in many instances.
Well, Judge, I believe that it actually was undue influence. If you look at the judgment, there were some very specific findings that talked about an elaborate investment plan that the decedent had established in, I believe it was April of 2012, prior to the time that the daughter moved into his house. And in the investment plan that he established, the testimony was that his investments would raise sufficient money for him to receive $1,000 per month, which would be added to his $1,700 per month pension and his $800 per month Social Security. So it would give him $3,500 per month. There was testimony that his expenses were between $2,200 per month, which was what his banker testified to, and $1,200 per month, which is what his daughter, who was living with him and who in her deposition testified was writing out the household bills, testified his expenses were. So clearly, the investment plan that was set up was sufficient to cover all of the father's household expenses and his expenses. And the son also testified that the investment plan that was set up was sufficient to enable the dad to pay all of his expenses and also allow the investment to continue to grow. And the banker testified to that as well. And what ended up happening, Your Honor, is after the daughter moved in, there became a completely different pattern of how the father was accessing the money and requesting money. And there was what I believe.
Wait. I want to stop you there because I've been listening very closely to understand the where influence comes in. Yes, there was a different pattern. How did that come about?
Well, Judge,
what was the different pattern, and what actions did the daughter take to bring about that different pattern?
Well, Judge, I think there was testimony that specifically stated from the banker where he testified that the daughter called him. The daughter told him that the father needed to get some money. And then the daughter apparently put the father on the phone with the banker, and the banker testified that he could hear the daughter in the background screaming and yelling at the father, telling the father that she had bills that she had to pay and that he had to take out money. And the father then asked for, on that specific occasion, a $7,000 withdrawal. There was plenty of evidence, Judge, in the record from both the decedent's investment advisor and the banker, where they both testified that they were so concerned about what was going on with the father and the daughter that they had made referrals to elderly services to request an investigation.
Unfortunately, we don't know what's in the record because we don't have a transcript. All we have are the judge's findings. But of course, it's incumbent on the party who's challenging the result as not supported by the record to have provided us with that.
But those are also in the judge's findings, Your Honor, okay. What I've just indicated. So, and then the daughter testified that during her deposition, which was introduced at the trial, that she had taken the dad's ATM card and was making withdrawals from the dad's ATM card. She testified that she wrote checks. The bankers.
But let me stop you there. Those actions appear to have been done without the father's knowledge or authorization, right?
I believe some of them were done without the father's knowledge or authorization, Your Honor. And I would point the court to the case of, in the matter of the estate of Alice Sharris, which is 83 Mass App Court 839. And in that particular case, Your Honor, the appellate court reviewed the decision of a lower court case. And in that case, the judge talked about very similar things where it was I believe it was a grandson or a nephew who moved into the home of an elderly woman who was related to him and started transferring funds from her checking account and banking accounts into another account. And what the court said there was, by doing these actions, what the person was effectively doing was depleting bequests to other family members and thereby protecting the assets that were bequeathed by the woman to him. And it's our position, Judge, that that's effectively what was going on here.
I
That the
understand, but
sister,
I'm not familiar with that case, but was that tried on dual theories of undue influence and dissipation, or was it simply an undue influence case?
it was an undue influence case, Your Honor.
I'll take a look at it.
Thank you. Yeah, I saw that you cited the Sharis case for the proposition that dissipating assets in a situation like this constitutes, I'm using this in quotes, unnatural disposition. Having read the case, I didn't see the term unnatural disposition used at all in Sharis. So I'm wondering if that case actually supports that proposition.
Well, with respect to the issue of unnatural disposition, the way that we're referring to unnatural disposition is that the father did do a will where he left the house to the daughter, and then he had his investment accounts going 60% to the son, 40% to the daughter. And what we were referring to in terms of unnatural disposition were things like what the judge found, that there were checks that were written to the daughter's boyfriend that the father told the bankers that he knew nothing about. Checks made to the daughter that the father told the bankers that he did not know about. And there was testimony from the bankers and the investment counselors that talked about father being confused on occasions about things that were going on in his own checking accounts. And in the Sharis case, the mother, the ultimate decedent in that case, also testified that she knew nothing about, these checks that were being written or what was going on with her banking accounts.
I noticed that you and Attorney Trundy cite different cases, seemingly with different elements, for what constitutes undue influence. In the case that Attorney Trundy cites, unnatural dissipation appears to be a specific element. In the cases you cite, I don't see that element delineated. So my question for you is, do you concede that unnatural dissipation is an element of a claim for undue influence?
Well, what I would say, Your Honor, is that in what's referred to as the seminal case,
It's really a yes or no question, right? Either it's an element or it's not.
And I would say that, Judge, in the primary case that talks about it, which was an SJC case, the Neal versus Brackett case, where it was established, they talk about 3 elements. They don't talk about an unnatural disposition. They talk about the 3 elements of a person who can be influenced, deception practiced, and improper influence exerted, and they also talk about submission to overmastering effect of such unlawful conduct. When they started talking about unnatural disposition, they, in subsequent cases, it was as one of the factors to look at, but it has never, in our position, Judge, been one of the factors where a court has said you absolutely have to have an unnatural disposition unless you're talking about undue influence vis-a-vis writing of a will. Because we're not talking about undue influence in our case in the writing of the will. The writing of the will was done in 2013, I believe, and Mr. Boyer, Michael Boyer, the plaintiff appellee, did not file in the probating of the will to challenge the validity of the will. So our position is, when you're challenging the validity of a will or a deed or a written instrument because you claim the person who authored it was subjected to undue influence, that's when you would need to have an unnatural disposition. When you're talking about a case such as ours, the facts such as ours, where we're saying the will may have been okay, but what happened was the daughter, as in the Sharis case, was effectively doing an end run around the will to end up with all of the assets by exerting undue influence on her elderly and ill and frail dad, for whom she was residing and for whom she was being the caretaker by pressuring him to deplete investment accounts. So the investment accounts were no longer, they were being depleted of principal, so they were no longer being allowed to grow. And she was using the money, obviously from her statements that the banker overheard, to pay for her own bills and not pay for expenses for the dad.
So I understand the distinction you're making. Now, the case that you cite for the proposition that unnatural disposition is not an element of undue influence, those cases are from 1920 and I think 1930. Do you have any more recent cases than that you can cite to that suggest it is not an element of undue influence?
No, I didn't find any, Judge, because all of the ones that I looked at on undue influence had to do with challenging a will or challenging a deed.
That's why in my opening comments, I made the comment I did. I think the reason you see that is because that's what undue influence is about. And it's a different claim when you're talking about somebody looting an estate before the decedent passes. And dissipation, I don't know where that leaves us, but I guess it leaves us with 50 seconds for you to say anything more that you'd like.
All I would like to say, Judge, is we believe that the court had jurisdiction. We believe that the claim was properly pled and that there was sufficient evidence for the judge to find what he found, that the plaintiff, the appellant, had the burden of requesting the transcript so that this court could have seen what other evidence was presented at the time of the trial to either supplement the judge's findings, and that clearly there's been no evidence produced that would support any claim that the judge was prejudiced against the appellant or that the appellant suffered from any kind of bias from the judge. And we would request that the court uphold the decision.
Thank you. Thank you both. That will conclude the argument.